All right, everyone, welcome back. Picking up work on S59 OML, and we are joined with counsel after some language was looked at by our friends in judiciary. And to not steal thunder, Mr. Tucker.
Good morning, everyone. Tucker Anderson Legislative Counsel. Here comes the thunder. I just finished up with House Judiciary, who took a look at the language from Representative Harrison's bill H-145, specifically the update to the disorderly conduct statute. Judiciary had a few questions and concerns, which because Eric Fitzpatrick and I are hardworking and excellent attorneys, we anticipated and had language ready to address their particular concerns. In the event that they came up, we did plan for multiple contingencies. Here is the contingency that came up in House Judiciary. Bit of context setting. Representative Harrison's bill and the language that you have considered adding to S59 added a new subdivision to 13 VSA section 1026, the disorderly conduct statute. It added a specific basis for a disorderly conduct citation in the context of a meeting of a public body. The language that was used was taken from the Supreme Court of Vermont decision in State v. Colby, which we have gone over a few times. House Judiciary asked the question, why not just amend subdivision 4, which is the current law that State v. Colby interpreted, and apply this to all meetings and assemblies instead of just those of public bodies? It was a great question, and the answer was that Representative Harrison's bill took a lighter approach and made it specific to open meeting issues so that it wouldn't frustrate any other jurisprudence or application for assemblies that did not involve meetings of public bodies. Judiciary would like to just apply this broadly to that subdivision 4, since it is in fact a clarification of how that subdivision is applied in this context. To achieve that, a new subsection C, which is on the screen behind me and is likely already posted on the committee's webpage by the excellent and hardworking Autumn, defines following: disturbs any lawful assembly or meeting of persons, which if you look at subdivision 4 is the second clause, which I am highlighting right now. This is current law. It defines that to mean conduct that substantially impairs the effective conduct of an assembly or meeting. And if you recall, this is the exact language and the standard that was analyzed in State v. Colby. Here is the adjustment that Judiciary is recommending. State v. Colby gave 2 concrete examples of when this threshold is met. They would like to include that exact language expressing the 2 instances or 2 examples of conduct in this definition. So it includes conduct that causes an assembly or meeting to terminate prematurely, or consists of numerous and sustained efforts to disrupt an assembly or meeting after being asked to desist. So that language, again, taken directly from the case. This also appeared in Representative Harrison's bills introduced. Representative Harrison introduced it in included it in the last sentence of the statement of legislative intent. And it was a bit of directory language to give these 2 examples to public bodies of the state in interpreting subdivision 6 in his bill. Judiciary, more direct here, just wants to include it right in this definition as 2 included examples. For purposes of this section and the definition in subdivision C1, meeting is defined to include meetings of a public body as those terms are defined in the open meeting law. This accomplishes one of the goals of Representative Harrison's bill, which was not only to provide the clarifying language from the court in this statute, but also speaking directly to public bodies of the state to say, yes, your meetings are also included here. They are also suggesting in a new section 4, which expresses legislative intent. Before you get into the disorderly conduct statute, it states that it's the General Assembly's intent in amending this section to conform subdivision A4, the lawful assembly subdivision, with the constitutional requirements articulated in. Those were the, we'll say, on paper, hard recommendations from House Judiciary when they did the walkthrough and consideration of this bill. They had a few softer recommendations or concerns. The first is that in the open meeting law, the chairperson adopts the rules that govern public participation and the opportunity for public participation. They spend quite a bit of time discussing some of the implications for potential criminal citation if it is in fact the chairperson who is adopting the rules and then determining when a meeting needs to terminate, which could be the basis for a criminal citation later. So one of their soft recommendations is to consider making those rules something that the public body adopts rather than just the chairperson. The other recommendation that they had, and this was echoed by a few members of Judiciary this morning, was to consider making those rules mandatory. Currently, they are discretionary, and they said there are potential criminal citations down the line, then every public body should have rules governing public participation so that they are formally adopted prior to being enforced by the chair at the meeting. They do not appear in draft 2.1 in front of you because Judiciary felt that was, as they said on the record, out of their lane, out of their jurisdiction, and more in yours, but they were concerns that they had in reviewing this context.
So what I think I want to do first is talk about the words on the page, and then we can go over into the two pieces that were verbally articulated by council. Is you hearing it?
It wasn't specifically just about the words.
Okay.
So I can wait.
Okay, yeah, so let's do words first. Any questions on what was provided?
I'll just say that I appreciate Judiciary taking a look at this, and thank you, Tucker and Eric, who's not here, for advising them your legal opinions.
Well, if there's no direct questions on this stuff, we can go over to the stuff that was just verbalized. I guess we can start with putting the onus on the public body instead of the chair. Yeah. I mean, I personally think that makes sense, but I don't want to put words in people's mouths. So I saw two hands come up at the same time. Jump off. Who wants it?
Thanks. So here's my thought is that I worry that if we are starting to change the responsibilities or powers of the municipal government, or, you know what I mean, what they're allowed to do, I feel like that always has some either pushback or unintended consequence or something that we would want to explore further with like the LCT and like, you know, boards and stuff like that, but only because I find that often these things seem benign and then they are not.
Which piece? The public, going with the chair to the body, making
Yes.
the decision making or crafting
Yeah.
the structure,
Yeah,
and not the mandatory.
yeah. It's not that I disagree with it as a concept. I think it's a fine concept. I just would be curious about the reason why it was crafted that way in the first place and what could happen should we change it. But I think aside from that, everything else that was suggested here and that Judiciary went through, like the the highlighted stuff that's on the page, not the soft recommendations, but like the stuff that's actually here seems like reasonable and fine. And I like the way that it's based on that one decision that is put specifically into the bill. I think that it makes the parameters really clear.
Rep. Hago,
I have no problem with the soft recs from the Judiciary Committee. I think we've heard from many bodies, legislative bodies, that they really want some teeth to be able to make rules and adopt them. And this would make it very clear. However, I just want to check with Tucker one more time. The statute that talks about the chairperson making the rules, can you point us to a language for that again? Just so I can read it, or could you read it to us, please?
I had it ready right here.
Wow.
Anticipatory radar is operating at a high level this morning. I wish you could have seen me in House Judiciary. I had a little more caffeine in my system. I was on it.
Tucker just
Well, you're
exists
pretty-
90 seconds ahead of all of us.
I'm impressed.
We're talking about one VSA 312 subsection H. So first, it states that at the meeting, the public shall be given, so this is a mandate, reasonable opportunity to express its opinion on matters considered by the public body during the meeting as long as order is maintained. So important proviso at the end. Public comment shall be subject to reasonable rules established by the chairperson. Judiciary was pointing to this and saying there's actually no mandate that the rules be adopted, just that if they are adopted, the public comment will be subject to those rules. Second, it's the chairperson that establishes the rules. And we talked about this in some of the initial discussion around this area of law. This is not unusual under rules of order that the chairperson would be capable of adopting the rules for the conduct of this comment period, unless the specific other rules, such as Mason's or Roberts, that were adopted have more specific provisions that would be binding. The concern that was brought up in judiciary is that because these are rules that are established by an individual, that individual has a high level of control over the public discourse that is permitted during the meeting, because they are simultaneously in a position of power to establish the rules that will be applied during the comment period, and they're the arbiter of when, for example, the meeting has to stop for violation of those rules. So their discussion this morning was around, would it make more sense to at least have the rules be adopted by consensus that would then be applied by the chairperson in the event of a disruption?
Rep. Hoover, then Rep. Nugent.
So a lot of the problems that were voiced in the people that came forward were that they had no ability to resolve things. This effectively gives law enforcement, if they happen to be there, the authority to say, you're coming to me now. It's out of the board or whatever's hands.
There are some things that you just said that are 100% on point and others that are not quite. So I'm going to try to walk back a little bit.
Caffeine. So.
You can get a coffee later. So the language that was in H-145 and it has been updated by judiciary takes a standard that already exists in law and that can be applied currently by law enforcement officers and prosecuting entities. And it puts it into law so that it is clear, one, that this is the standard that applies in statute, and two, that yes, it is applicable in the context of meetings of a public body, right? Because the language right now applies to any lawful assembly or meeting of persons, broader than just meetings of public bodies. And the case dealt, as we've discussed, with the commencement ceremony at a private academy. There's not a meeting of a public body. So what you have done is you have taken the standard articulated by the Supreme Court. You have expressly applied it to this provision of law in statute in an attempt to clarify for law enforcement and prosecuting attorneys. This is what's being applied here. And you have expressly included meetings of public bodies under that subdivision to give some direction and coverage for these public bodies that they're also incorporated here. Now, the chairperson determines when a meeting commences and when it may need to either temporarily adjourn or terminate because of the conduct of a member of the public. If there are rules that are applied when the meeting is terminated, the chairperson is the one determining at that time whether someone has gone over their time or is speaking on matters that are outside of the agenda for that particular meeting, or any number of other possible violations of rules that are meant to maintain the order of that public comment period. There are two ways that this could then escalate from, for example, the pausing of a meeting or a request for the individual to desist, all the way up to potential criminal citation. And those two examples that were called out were, one, the meeting has to stop, and not a temporary stop, but like a significant duration. The business of the public body ends because of the conduct of this individual. In State v. Colby, the speech that was interrupted was 8 minutes long. It was continuous. It never really stopped. And the disruptive behavior lasted no longer than 30 seconds. And the Supreme Court said that is not a substantial impairment of the effective conduct of that meeting, especially because that assembly was a 3-hour assembly. So 30 seconds in the context of the entire 8 hours with the speech not really being affected didn't meet the standard. But if the meeting had stopped, or fact pattern 2, those individuals did not leave voluntarily, but instead continued to attempt to disrupt in a serial manner, then you have the second fact pattern pointed out by the court. An individual's actions consist of numerous and sustained efforts to disrupt an assembly or meeting after being asked to desist. The court also provided that these are not subjective standards. They are not based on the content of the speech or what the person is saying. It is about the volume, the force, and the persistent continuous nature. So duration is one of the terms they use. It goes on for quite a long time and the meeting can't function. That's when you get to the substantial impairment level that might lead to a criminal citation.
So under this language, which doesn't say it's the chairperson's exclusive prerogative to declare that you've harassed the meeting enough, and we're not going to suspend it, but we're going to pause it several times. A law enforcement officer in the room would not activate himself or herself just based on this language.
Right, and
There has to be a rule violation.
that would be because the two objective standards that we have here, which is, this is a non-exhaustive list. These are just the two that were called out in the case.
Yeah.
So we have an including clause. These provide some objective criteria about how the meeting is disturbed in its order. So the chairperson is going to have to take some sort of action prior to either of these being triggered. Has the meeting terminated prematurely? That's something that the chairperson, or actually not sure if Robert's rules allows the body to move to adjourn early, terminate the meeting prematurely, but some action has to be taken by either the chairperson or the public body. And then the second, that last clause, so consists of numerous and sustained efforts to disrupt an assembly or meeting after being asked to desist. there has to be a formal request that the individual desist or stop whatever their acts have been to that point. So that is something that the public body has to do prior to a law enforcement officer acting. There may be a whole host of other criminal provisions that could apply here based on the conduct of the individual within the meeting that would not require, for example, the public body or the chairperson to act in this context. But for this disorderly conduct violation, yes, someone's going to have to ask the person to stop or leave or terminate the meeting.
Provision. Let's see it.
Yeah, I was curious about the word adopt, and if that would allow a chairperson to involve their committee in the role, in the whatever rules they come up with. Even if we don't change that, they could still build some consensus around that.
You're talking about amending one VSA 312H to eliminate the use of the term established and replace it with adopted by.
Possibly, or when we were talking about whether we change it from the chair adopting the rules versus the committee. Yeah.
We would change it to adopted by that point because bodies adopt rules.
Grab copy.
Yes, and at that point, if we're doing that, and if the public body wants to be able to have that, should we put in they shall adopt rules to make sure they're there on the books and people are aware of them? Is there terminology like that that we could say, you need to make, if you want to be able to use this, you need to make the rules. You shall make rules.
You could certainly add that in, and that was one of the recommendations from judiciary. And it wasn't a prior to you using this authority, you have to adopt the rules. It was every public body has to adopt rules governing public comment. That was their recommendation.
Yeah, right now it would be a voluntary thing. And on that one piece, I given the timeline right now and knowing that we're gonna pick up more of work on this conversation with a separate bill next year, I was a little hesitant of making it mandatory just for this interim period and then having that be something we could take a deeper look at when we start taking a look at this stuff next session. But that was just my personal opinion.
I agree with the chair. I think starting to make those changes is going to we would need a lot more testimony and conversation to make those, to get them right. I don't think they're bad ideas. I think they're fine ideas. I just think now might not be the time. And it's nice to know that we're gonna work on it next session in a different bill. Great.
Yep.
Sounds like it's something to look forward to.
We've been talking about that within the context of all of this for
Yeah, but
weeks with this Harrison harassment piece.
yeah, and the way that this looks now with the changes that, were suggested by judiciary, the ones that are actually, in this draft of the bill, seem totally fine to me. And a good way to handle the problem.
Did I see some other, no, thank you for that, yeah. Rep Pitzel and then.
Has
I did
Representative
see-
Harrison seen this graph that we've added this to our bill?
I don't know. I have not sent it
Okay.
to Representative Harrison.
I'm glad that we've left, that we have something in here, we have some teeth.
I know he's aware of the structure of what's going on here. I don't know if he read the words on the page yet, but when I read into him this morning, he was just very grateful that we were working towards this language. So I at least did have that point of contact and expression of gratitude to share with the committee. So were there any other hands on this piece right now? I mean, I guess like what's the hanging question right now? The public body over the chair, which was the other verbal recommendation.
Yeah, that's a whole other thing.
It's a whole can of worms.
I'm just asking.
Yes.
Hands for comment.
Yeah.
So with that, I mean. feel free.
I feel like it'd be opening up a can of worms.
And again, that's another piece that we can flag for further consideration. It's really after seeing it, such a steep inflow of concerns from municipalities that none of us anticipated. Wanted to be respectful of that. Thank you to the committee for working more on this. So
Can we vote on it?
I think we certainly are sitting here and it's marked for discussion and vote.
All right, I make a motion that we approve this draft. It's no,
Hold
yeah,
on one
no,
second, I got a
Tucker
hand
said
from
no.
Tucker.
May I pause? I updated to version 2.2 to make a technical correction and updated the timestamp since I had
Okay.
just finished this upstairs and now my computer is dead.
Nice.
Do you need a
Can we
charger?
just get you a charger?
I know. Maybe
Like, can we just get a charger
We need this
here
one?
for you?
Yes.
end of session gift.
And it has a very long cord.
Second.
You get.
Where's that fall under? Is that capital bill?
Yes.
How's that? All right, we are live.
Who's gonna call the roll, Lucy? Oh,
Yeah, we got the forms.
Just want to report this.
I.
Into an error.
The open meeting law is finally gonna crash.
Spectacular fashion.
We bragged and said that it would make the future, and it's like, haha, didn't predict this, did you? I'm going.
I'm still moving.
Yes, it's. Back in 2016.
Did you say that was gonna be draft 2.2, Tucker?
Yes, timestamp 5:15. At 11:55. Pass through and make sure I got rid of all the highlighting.
Hello, Kate. On the side, looking at the email you sent about the HGMO reports workbook.
Oh,
Is there a way we can actually put our name in that or?
That's all we've been talking about.
Oh, okay.
It's forthcoming.
My bad. Missed that one.
May everyone have this in their inboxes and I'm gonna.
Gonna post it.
The technical correction is that in the definition of meeting, I had used plural meetings. So the technical correction was removing an S. So that it states that it includes. So I hope that's what it says, my computer crashed.
I'm looking at it.
She posted about to get hit, yeah.
The inner emails.
Oh, it's in an email.
Were you posting it to Autumn or just you?
Yeah, but if you guys wanna look at it right now. Okay.
Got it.
One other technical correction, version 2.1 that I didn't cover because the exciting news. It's too exciting. Was that the section heading for 1-SA 312. When I was doing this review, I noted that there was an error in there that, as far as I can tell, has always existed in the open meeting law, which is that the section was titled right to attend meetings of public agencies instead of public bodies.
Oh,
Ooh. Say that one more time? That was mid keystroke.
me
One
too.
VSA 312, the title of that section was right to attend meetings of public agencies. So that is corrected to public bodies.
Right at the bottom of page 1.
No confusion with the Public Records Act.
Hmm.
Okay.
And it's posted if anyone prefers to look at it on.
Okay, thank you.
This is the version you need to send to them.
Change was. Bottom of the page, change.
Okay.
With that long. Agencies, still bodies.
And there was one more before that. I don't remember. Wasn't so substantial.
Yeah, it was that.
You want me to make the motion again? Or does it still stand?
It's still stand, we didn't break.
Oh,
You just have to.
Yeah, I gotta like
Discuss.
direct, yeah, I gotta see the. Everyone comfortable?
Yep.
And the motion's been made, Evan, so, I move that we find S 59. An act relating to amendments to Vermont's in meeting the law, draft number 2.2. Favorable. Any further discussion from the committee? The vice chair will call the roll.
Rep. Boyden, Rep. Pincinel. Yes. Rep. Morgan. Rep. Cooper Burlington. Rep. Coffin,
Yes.
Rep. Stone.
Yes.
Rep. Cooper of Randolph,
Yes.
Rep. Nugent,
Yes.
Rep. Waters Evans.
yes.
Rep. Byron,
Yes.
Rep. Pango, yes. And the vote is 10-0-1.
Right. A lot of conversation involved with that one. But that was actually like that was a great learning experience too. So, all right, we will break for lunch now. Good.
Oh,
the
sorry,
reporter of the bill,
reporter is
sorry, the
Rep.
reporter
Waters
is-
Evans.